Last week was the day. Last week on Monday was there to have your heads of argument, not in pieces.
I apologize, my lady, and I'll be as succinct as possible. I'm on page 135, the evidence of the accused, my lady, and the arguments that I want to present are the following. Firstly, page 141, I submit that the whole question of the diary is mute. There was no such diary. So Apollo's evidence can be accepted that if he had seen something like that, anything, whether it's a diary or document related to this matter that could help solve it, he would have kept it and put it into the SAP 30. On page 146 of my head, my lady, the point is that all the time as the accused relayed the events of that morning coming back, the deceased was defiant and fighting. The oral argument was as usual. There were no indications on the accused version that she was going to get up and commit suicide, if I could put it that bluntly. In general, and I've said this, my lady, my impression of the accused version is choreographed very carefully in total. And I'll take you to a couple of aspects of that succinctly.
Which page are we on? Are you arguing on regard to the accused?
The accused
testimony now.
Testimony. And
which page is that?
I'm now on page 147, my first bundle of heads. I've made the point of Miller and Amiria testifying the drinking. The carefully thought out story told by the accused. That is what I said just before lunch. And on page 148, I make the point, if you read his evidence just before that, page 235, you get the sense of his evidence that he is rationalizing. I stated this in my head, the top of page 148. He's building up to an argument why Susan will go commit suicide. He knew he was trapped. So that's the point I want to make. Page 149, it was dealt is evidence that she tripped, she fell. You expect her to fall forward and not lying on her back, ending up lying on her back, the way that he portrayed it in his evidence, and I quoted on page, my head's 148, and the record page 2337, line 11 and further. And this whole issue of the injury to the nose, but there was no blood seen by him. That makes his version of that whole incident very, very suspect. Also, the point I'm making that on page 151 of my heads, why does it repeat the question of wearing her gown? It doesn't fit in his evidence here if you read it. But I've quoted it from page 2342 as if we wanted to emphasize that the court must accept his evidence that when he entered the bathroom, she was wearing the gown when he picked her up and called out for help for Desmond Anders. Page 152 of my heads, the salient point my lady, that easily he could have unlocked that door. The state does not accept his explanation that he didn't thought of trying to unlock. If he went to the door, tried to open it, the logical explanation is that you should try and open that. And it's a hotel room. We all know about it. The accused is a well-traveled man. He's got kids. He's been to hotel rooms so often. It's illogical that he would not have thought of to open it. And again, the same point is made on page 153 at the top. It's just absurd, strange. And he said emphatically that he did not try, and he couldn't try, and he didn't know he's not a handyman. And again, this point that he makes, that she was 100% fine when she went into the bathroom, compared to how she was found there with all the other injuries. How could he not have seen that? Or, and I'm making this point on page 154, from the evidence that cut of the foot. Did she complain of any pain at any stage? Was asked of him. He said, no, she didn't. Improbable. Highly improbable. And this is the point important where I spoke about the wedging, my lady. My head's on page 155 at the top. He said, I came through around here, I see the feet pointing this way. Then I knew why the door was not opening. I pushed the door open, I get through the door, I came around here. On his own version, my submission, he did not see the feet when opening the door. And this is, and I'll get to the contradiction, where he wedged the door open, entered, and then only see the feet. He's carefully crafted explanation of what happened there, and it was not Daniel's that, after unlocking the door, opened it a bit. Is highly suspect. And to add on that, on page 157 of my heads, again, Daniels could not know the tightness. How could he not know about the tightness of the cord around the neck? Or how is he just so completely wrong that he kon enige moeite om enige knope los te maak? Of how could Daniels be wrong to die deur maklik oopgemaak? Or mistaken with the legs that he saw? And the reason why it's important that, I submit, that the accused differs here from Daniels is that he needs his position of the body to differ from the position that Daniels saw, because he changed it after Daniels left. And I submit his thinking at the time was, this didn't really look as if she hanged herself, because she was, as Daniel's evidence is, her legs was flat. It was a single cord. Let's tie it now, a double cord. It's hanging, as we can see on the exhibit photographs as the police found it. That looks much more like she hanged herself when the cord is hanging like that. Another contradiction in his evidence, I pointed it out on page 158 of my heads. Are you able to comment on the exact manner in which the cord was wrapped around the neck in terms of loops, knots? I can't comment on that. I can't. I wasn't paying attention of how many times or what type of knot it was. My submission is that contradicts when he testified at page 2356, line 7, the knot around Susan's neck was very tight. It was not a loose knot around the neck, it was a tight knot, if I can call it a knot. It was a tight lasso or knot around the head. And Mr. Daniels wiggled it and with his hands and he took it off the neck. This is part of the contradiction. I want to refer to the record, my head, page 160, and the record top there, page 2408. Here he states, the accused, he opened the door, but we couldn't wedge it open. My wife was blocking the entry as she was hanging behind the door. Compared to the record at page 235191, how did you know that she was at the back of the door? Because I could feel when I opened the door, the first thing I could see. When I opened the door, the first thing I could see. And then he states, all right, so her feet were hanging, her feet were pointing towards the bases. Then when I managed to wedge myself, the first thing I saw was Susan's feet. Compared to when he opened it, and he couldn't wedge it open. I think I've made my point there, my lady. In his evidence, page 163, and we've dealt with it before the lunch, my lady. This whole thing of the divorce talk was no surprise to Susan that early Sunday morning. I referred to his evidence at the record page 2433. They did speak when they had their major roles about divorce. I would say to them, I just want a divorce. Again, I want to put it in the record for my lady, the reference. At my head's page 167, record page 460, line 1, where he states, I can tell you that when I opened the door and wedged myself through, I was looking down, and the first thing I saw were her feet. That's the first thing I saw. So, what I submit in argument on page 179 is that the accused reconstructs, he's argumentative in the way that he testified and answers questions. He tried to find inconsequential differences between him and Daniels, but he can't explain the real material differences, such as he being completely naked, the gown was inside out, I was holding her, the tightness of the noose and knot, the legs in sight on opening the door versus he saw her feet after he wedged himself into the bathroom, and the way the cord was single versus double strand. Page 182, an example of being argumentative. And the point I make on page 184, the character of the accused is he's in a habit to lie and to tone down things. And the court certainly must take this into account when the court is weighing up the two versions as testified by the accused and Desmond Daniels. Desmond Daniels was taken completely by surprise. He's an innocent handyman, being asked to do his job. He did it exemplary. He was courteous, did barging, he waited for the accused to enter, and there's no reason why we should not accept his version of what was found behind the door. Again, page 185, example of how the accused is being economically with the truth. I would submit how he decided, or explained to us how he moved his arm back deliberately didn't want to make contact. I preferred there to record page 2548. I was trying to hit her arms away from me. I never once was thinking I wanted to make contact with her in that regard, no. My submission is that the accused is shying away from the fact that he did hit his wife. He's just being economical with the truth. And lastly, the argument on page 192 of my heads, he states specifically at record page 259595, yes, I see the handle, advocate. You've never tried pushing it down or wiggling it, that handle. Of course I did. Now if he did that, why wouldn't he see or saw that this was a groove? It can be opened. It just boggles my mind. And then it was put to him. I tried to get into the door, opening the door with a handle. How else would he enter the door, advocate? And did you direct your eyes there to see or looking, see that groove? No, I mean, to me, that looks like a screw. What looked like a screw? Well, the part that you insert the screwdriver, the probabilities completely against the accused that him having screwdrivers at home, using screwdrivers, would just say that he didn't try to open the door. My lady, those are the problems that the state has, contradictions and improbabilities that I highlighted and I referred extensively to the record of the accused evidence. I then want to move on to the evidence of Dr. Perrimal, and I'm in my second set of heads on page 28, my lady. I refer to a number of case law first, that's common to the sport as well, so I'm not going to look at that further. The point at page 31 that I'm making from his evidence on the hyoid fracture, my argument is that this can occur in both death caused by hanging or strangulation. So that doesn't really take the matter further to one way or the other as to how she died, the cause of death. On page 34, I submit the criticism against Dr. Khan that he got locked into a view, it's difficult to entertain something else. I would submit that Dr. Khan did keep an open mind. There was a reasoning process in his mind going on. He was quite correct to have a suspicion that this is not a suicide hanging. Seeing the feces, seeing the blood in the bedroom, the way that she lied naked, the gown belt was not there. This is just not an ordinary hanging. And at that time already, he didn't see a knot imprint. And, as I understand his evidence, an incomplete ligature mark. And then, we've been through that, so I'm not going to unpack it unnecessarily, my lady. On page 34 and 35 of my heads, and I've dealt extensively also in cross-examination with this aspect that the ligature was not completely around the neck. There was a gap. And not as Dr. Permal tried to say to us, it was almost. It was a big gap. So saying that it was almost circumvented is exaggeration. And I've already alluded to the fact that the front mark contradicts fundamentally the back mark. And the statement submitted, this court can't, based on the differences in the pathology and the experts that came to explain this, exclude the possibility that this is lividity lines because of creases in the skin of the neck. And I refer there in my head on page 35 to this aspect. Page 36, I deal with the aspect of what the defense put to the court, also through Dr. Loftus, that the feces, it was contamination or step marks. My submission would be just the sight of it, that they were too isolated and far apart to infer step marks. There are no step marks leading up or away from any of the stains that were photographed in front of the bathroom and outside. If it was contamination and transferred by the shoe, you would logically expect a discernible step trail visible in between. So, and there is long, clean distances between the marks inside and outside. They are isolated. I make the point in paragraph, page 37 of my head, the disadvantage that Dr. Promel has in his observation as a second autopsy, specifically to the distortions of the anatomical positions because of the stitches in the neck. Dr. Abrams also strongly made that point. So any measurements that it took, as referred to in the record page 2671 that I quoted there on my head, page 37, that doesn't mean anything and must be carefully considered before any weight attached to it. I make the argument at the bottom of page 37 that parchment seam can also be caused by prior application of force to the neck. This whole issue of the fracture of the thyroid cartilage is dealt in my head on page 38. Dr. Kahn was there first-hand. He stated there was no evidence of the incision. He observed the fracture. The point is, he was there and it was fresh. The first autopsy. And the same argument that he observed first-hand, on the bottom of my head page there, the deflected nose and the teeth imprint. I would submit that not much pressure is needed to be exerted to smother a person with a cushion. Minimal pressure. I'm at the top of my head page 39. There was a teeth impression that Dr. Kahn saw. Then the whole issue of the injuries, the hemorrhages, what I referred to is on page 39. My submission argument on page 40 is, when is this sustained? Was it ante or post-mortem? It does not prove, again, hanging, nor strangulation or smothering. It doesn't assist us in getting that answer. if this hemorrhages occur, what I've quoted there on the record, page 2691, argue that it was caused during CPR, and then she must still be alive. And on the evidence that what we have from the accused as well as Mark Thompson, she was already dead when they entered the bathroom. Firstly, the accused and Desmond Daniels. Now, Dr. Khan is adamant in his evidence, put it up there on page 42, there was an injury to the nose, the blood was then going down posteriorly, it was swallowed down, the esophagus, etc. The argument is not even the accused noted a bleeding nose. Such an injury, I would submit, is inconvenient to you. You would either have cut up or sneezed blood, or definitely complained. And if it's not a nosebleed, where does this come from then? And what caused it? Then it must be a lung injury, as stated by Dr. Khan, a perimortem injury to the lung. Page 43, again, the ligature mark. I'm not going to belabor that point. Page 44, I'm dealing with a very choreographed version put forward by the accused as what happened when they came back, made that point. Then the whole issue of what exactly did she die of? On page 45, my argument is that Dr. Khan found as a cause of death asphyxia and external airway obstruction unnatural. The indictment also states, and or other violence unknown to the state. This is why I've made the point before lunch, is that one must remember there was a staging here of the death to look like hanging. That is why it's so difficult and why we have differences from the pathologists as to what exactly happened. How did she die then? Because it's obscured. And we can't have a certainty on this. What we can have a certainty, and that's the state's, in a nutshell, the state's evidence. All the evidence together points to the fact that she did not hang herself. She was placed there.
And do you believe that the state had discharged the onus to prove that beyond reasonable doubt?
Yes. Given all the evidence, once you've unpacked it and looked at it, and I've referred in the beginning to the law and the legal principles, some of it you might think, wow, I don't know. This maybe more favors the accused, specifically coming from the pathology side. And that's why I make the point on page 46 of my head. The post-mortem examination, I've underlined it there, though, is simply not possible in a case like this to be adamant about the cause of death. And this is a concession made by Dr. Permore in his evidence here compared to his post-mortem report. So he does not express a strong opinion. Why not? If hanging was then so clear, you would have expected him to be much more stronger in his opinion there. Now, I'm not going to deal in Dr. Permore's evidence, my lady, with, I think there were 9 different cases. I've listed it here, put the relevant parts of it in my head. What the state wanted to show is, firstly, there was a case where Dr. Permore overstepped his opinion and he was discredited by Judge Khadebe in his judgment. There were other cases where he made wrong findings. Other cases that he was not involved at all giving evidence, or his evidence was assessed and pronounced by a court. So what it says is that it's not a clear-cut science, pathology. Secondly, Dr. Permel, in all his experience and wisdom, can also err, and that the court in general, and this is what I say also as far as Dr. Khan and Dr. Abram and Dr. Loftus' evidence is concerned, must be careful what weight to their opinions on the salient aspects that we're trying to distill to find out what caused the death. And can you with certainty say that she did hang herself? That is from a pathologist's point of view. And that is why my argument will in the end also be that you can't disregard the eyewitness evidence of Desmond Daniels. And what is striking from the pathologist's point of view, from the defense, is that they have started off with their opinions based on the story of the accused. And that is not objective and what you expect from experts like that. And it went further in the way, in the manner that Dr. Perneri Peter was put on the stand here to express her opinion. So that's why I argue on page 49, one must be careful and cautious when you evaluate the evidence of Dr. Permel. And I must say, going through it again, and as I've explained it here, and I'm almost finished with these, he did make certain concessions, and I've listed it here, and I'll quickly take the court there. But before I get there, on page 53, I'll make the point where he doesn't want to take into account there. This is how different from before. What the accused has said, and it's put to him in cross-examination. It's speculation. And he says at the end of page 52 of me, I don't know what the accuser said, but it cannot be that it was absolutely tight around the neck. What sort of expert disregards that? Well, then he's in direct contradiction with what the accuser said. So, which version do we take now? The version of Daniels? What does he say about Daniels? He didn't want to commit himself to that. He was questioned on page 58 of my head about the lack of bruises, that there's no bruises or skin externally in that area, and I'll read the record, page 2961, line 15 and further, as well as exhibit QPQ. So the states that the combination of the indicators were absent. The knot imprint, the incomplete mark, the lack of friction abrasion, the parchment isolated and irregular, and the lack of bruising specifically at the back of the neck. Page 67, the concession, one of the concessions that I referred to, where he said, top of the page, I quote, the record 2984, as I indicated earlier, the news was extremely tight and I expect to see more of the ligature at the point of suspension. This may make his and the defense's whole argument that she hanged herself, put it that it's hanging there. There is no real basis for it compared to what was seen by Dr. Khan, confirmed by Dr. Abrams, and the whole potential theory of Colonel Pullman. And again, in contradiction, page 75 of my argument hits the left eye applying a force applied to her, but that does not fit the version of the accused. I've dealt on page 77 of my heads with the aspect of and it's wrong, it should read the deceased did not attend this when mistake the accused. What I want to draw the court's attention to is further down that it's not reasonable to believe that the deceased could have sustained a severe abrasion on the shoulder, 2 lacerations and an abrasion respectively on both feet, plus the laceration on the left eyebrow in one falling event. Where she would try and, if she tripped and try and break the fall, you would expect abrasive injuries on the elbows or knees and hand palms. But none such were present at the time of her death. Page 85, I refer again to why didn't she complain that she was swallowing blood. And on page 86, another concession by Dr. Permal, and it's related to the evidence as depicted there. What I can say is that it's not at or about the time of her death the blood being cast, only caused by direct blood caused by the accused, that is the fist or elbow, is my submission. And that happened on the version of Dr. Permal sometime before she died. I've made the point already, page 90 of my head, on what version does Dr. Permal base his opinion, Daniels or the accused. And it's important, and I'll argue, my lady, that it's strike law. The state does not have to close every avenue of escape. And that's why I would submit the only reasonable conclusion, considering all the evidence, is the staging of the death to look like hanging. And it's unsure exactly what and how caused her death. Then going on to the evidence of Dr. Khan, my lady. Page 92. He was heavily criticized that he made up his mind before he left the hotel there to write up his notes on the scene. My submission would be that that is why specifically he went to the scene. He was asked, it's a standing order, as I understand it, that pathologists go out if they are called by the police. And it's not only to try and estimate the time of death and to be there. It goes back to what our constitution will say in chapter 3, section 41 of cooperative government, between police force, the Western Cape Government Pathology Services, that they do assist each other. And that's not that he overstepped his mark there at all. He had to visit the scene and observe there. And it was reasonable, and I make that point on page 93 of my head, to form a suspicion, the blood stains, etc. He is also adamant that the feces, that it was feces, sort of a dark brown color material present, it had a smell, a bit of a smell of it. It looked like it was feces. So altogether, I'm making that point at page 103 in my argument, that he was confronted with a picture of doubt that this was a suicide hanging. And I've referred to the record why I say so. He was taken to task in a number of aspects in cross-examination. At page 113 of my case, the court, in deciding what, beyond reasonable doubt, was the cause or likely cause of our death, and then I deal with that question and the answer to it on page 114 of my head. What we can't take out of the equation, my lady, is that Dr. Khan was there in person, and there was no ligature at the mark on the posterior aspect of the deceased's neck. The way that he examined the scene, the way that he did his post-mortem, there's no indication that he would just simply miss that. He knew he dealt with hanging. Now I can't take it further than that. Why would he miss something like that so completely? So what we are showed by the photographs of Dr. Permel, and may I just add, it's quite strange that Dr. Permel never produced those photographs either to Dr. Khan afterwards or to the state. It was only in his evidence in chief that all the photographs were disclosed to the court. Now what's interesting, when he was cross-examined, page 119, I referred to the record page 1035. It was put to him that she was bleeding from, amongst others, her toe, and she screamed at him, "I've cut my fucking toe." What do we have to make out of that statement, amongst others? Again, it ties into what the state would argue, a carefully choreographed, put together version created by the accused. His evidence, as I understand it, he didn't see any other blood. The important thing, my lady, and I will end off my argument in chief on this aspect. If you turn to page 131 of my heads, I quote from the Eastern Cape case, Motor Vehicle Insurance Fund versus Kenny, 1984, the one we're missing. It was found that direct or credible evidence of what happened in collusion must generally carry greater weight than the opinion of an expert seeking to reconstruct the events. And this is the caveat that I would like to leave the court. If one tried to put together all these pieces and come to the mosaic of the evidence. I'm not going to deal now really with the evidence of Dr. Abrams, who wasn't she was present, but she didn't physically get the post-mortem. But she concurred, broadly speaking, with the findings of Dr. Khan. All I want to say, and that's on page 130 of the piece, on the evidence of Dr. Loftus, that, and I want to really stress this, he worked only from photographs alone. and it's a secondary method. And I would submit, with the greatest respect, that he is biased towards the accused version, specifically where he testified as to the time of the death and why there was urine found where she was lying, that it was so close to when she died compared to the objective facts that mitigates completely against hanging. And then at what time did the deceased, on the version of the accused, entered the bathroom? I've dealt with that on page 131 in my argument of the doctors. Unless there's anything else, I've tried to be as succinct as the court time.
I'll address you in the examination. But of course, the tried question would be why you would argue that in the context of factual matrix, just the Lewis version cannot be seen to be reasonably possible. Thank you. Understand?
My lady, may I please make a proposal?
Thank you.
I do need time to study this supplementary memorandum of my learned friend. I'm not sure what the time is now. I would imagine in my mind's eye about 3 o'clock. May we adjourn today? And I give the court an undertaking that if we commence tomorrow at 10, I will not go beyond 4 o'clock. I will sit tonight and clip and curtail and condense. And my intention is to address the court tomorrow in terms of 10 main points. And the court knows what my thinking is. It is set out in my heads already.
If you say we won't go beyond 4 o'clock, does that mean you won't go beyond 4 o'clock?
As the court pleases.
The problem that I have with that is that there's still re-examination. So if you want to start at 10, I would give Mr. Van der Kerk no more than 30 minutes in his re-examination. We can start at 9 and 9:30. Then you should be done by 3:30. We can even cut lunchtime short.
My lady, may I, obviously I must fit in with what the court wants, but if we start at 10 and take half an hour for lunch only, would that suit the court?
And then what time do you expect to be done? Yes, I'm going to start court earlier.
As the court pleases.
What do I do if you come to a certain time and you tell me, look into my eyes and you say, sorry, you're not done?
My lady, that in theory could happen even if we start earlier. My problem is I've got 3 suitcases and I walk with a crutch. So I have a whole entourage that has to help me get my stuff here. And to get to court in the morning earlier than that is very, very difficult. But I shall be here at 9:30, my lady.
Thank you. We'll start at 9:30. We will be done with closing arguments tomorrow.